the 368 will not apply to any provision of the Constitution in this chapter. Is that not against basic structure? If the argument is, at least I didn't argue the basic structure, but otherwise that's also against basic structure. Why don't you set aside the entire chapter? Every provision other than one, which relates to Andhra Pradesh, starts with notwithstanding anything in the Constitution. Now, as far as Jammu and Kashmir was concerned, they had an added protection, the proviso. That constitutionally means that the complete merger that we are talking about, dehors the proviso, could never be done. There could be an argument as far as other articles are concerned. You may still apply, use 368. You may argue that. To what extent it will be upheld or not is a separate issue, because in some of these articles, even treaties cannot be changed. Some of these articles have treaties, Mullah, between the government of India, which was entered into in the past, cannot be changed. So whether 368 will apply or not, we are not into this. I'm just getting you the scheme, Mullah. So Mullah, I'm done with this. Now, Mullah, I come back to try and finish as quickly as possible, because a lot of eminent counsel are waiting for me to finish, which I wouldn't wish to do, Mullah. Then, Mullah, now I come back to that argument, Mullah, that I made yesterday, that once the dissolution took place, 356 could not have been imposed as a matter of law.
That point to make.
And if 356 couldn't have been imposed, all that happened by virtue of the power under 356 is all illegal and void. Because the structure of the Jammu and Kashmir constitution is entirely different. My lord knows that any act of dissolution has to be done on the aid and advice of council of ministers. That applies not just to Jammu and Kashmir, but to the rest of India. No dissolution of an assembly can take place without the aid and advice of the council of ministers. Therefore, Mullahs, constitutionally, the dissolution on the 1st of November was void. And you can't interpret the act of the governor and the powers of the governor and the responsibility of the governor different from other states in India. That as far as governor of Jammu and Kashmir, he can do it, but the rest of the India, governor cannot do it, because the provision is the same. So if that action is bad, 272 has to go, 273 has to go. And even if you assume that action is good, you can't exercise this power under 356. So 272, 273 will still have to go, because the power is only the power to make law. You are the delegate of parliament, of the legislature. You can only make law. You can't change Article 3. And whereas my learned friend, the learned Solicitor General, cited several instances of 356 where Article 3 is suspended, but not with reference to the change of Article 3. That's the usual procedure that was followed. But not to change to amend Article 3. That is never the power given. And that is apparent in 357 subclause 2, Mullah. Kindly see 357 now. It's in my note itself, Mullah. Shall, to the extent of the incompetency, cease to have effect on the expiration of 1 year after the proclamation has ceased to operate. So how could 272 be issued? Any law made has to expire after 1 year under the Constitution of Jammu and Kashmir. One of the distinguished counsel on the other side didn't read this part. He read Mullah 357-2, which is different, which is the Constitution of India. So how do you, Mullahs, amend Article 3 of the Constitution and justify it either under 356 or under 357, because the legislature has the power to make law? How do you do it? And that also temporary emergency laws, remedial laws. It was original 350.
Just read the last portion once again.
Yes.
One, it says law made. Is it talking about legislation made, legislation in form of laws or enactment made? And read the last part.
Last part, which shall so cease?
Yes.
To have effect as sooner.
To have effect on expiration of period after the proclamation has ceased to operate.
That's correct.
Except as respect to things done or omitted to be done before expiration of the said period.
Yes.
This part will have to be explained. Unless the provisions which are so ceased to effect are sooner repealed or reenacted with or without modification by act of appropriate legislature.
That's correct. So, Manoj, how can that appropriate legislature, when it comes into being, ever do this?
Just two things, Mr.
Yeah.
Sibal. One, is it dealing with laws made and not with the effect of, will it apply also to Article 370? or for that matter,
Once there is,
Article
once 356 is there, it will apply.
we are not, it's a matter of interpretation.
Yeah.
It's not a matter of taking sides.
I agree, Mullah. I'm not taking sides. I'm only taking my side, Mullah.
You are doing that.
Yes, right. That I'm entitled to take, hopefully, Mullah.
One, it says law made. Will it also apply to the power exercised by the legislature in terms of the constitution? One aspect. The second is, to the extent of incompetency,
Correct.
cease to have effect on expiration of period of 1 year.
Correct.
After the proclamation cease to
Right.
operate, except as respects of thing done or omitted to have been done before expiration of that period.
Correct.
So what it also protects is whatever has been done or omitted to be done before expiration of that period
Correct.
will be protected.
Correct, absolutely.
Will this not get covered in that part?
It won't, because this is an amendment of the Constitution. It's not a law.
Then you aren't contradicting yourself.
I'm not. It's not a law. This is not a law, Mullah. This is an amendment to the Constitution.
So what it talks about is laws, not
No, because you're a delegate of Parliament, of the legislature. In other words, whatever power the legislature has to make laws, you can make laws. Mullah, 356 is not an omnibus position to Mullah take over the legislature and do what you like.
Mr. Sibal, when we interpret, we have to interpret the section without taking, you may say in the contextual interpretation, we have to take the whole background.
I'm sorry to say that's covered by Boma Emalats. That's not covered. That's not. There's no cavil to it. That's covered by Boma. And I've cited all those passages of Boma to your lordships already.
Just one.
Let's not find any other power. Chip says, when we interpret, especially because your lordships interprets the Constitution, we only make arguments. It's for posterity. It's not for this case or that
Yeah,
case.
you don't have to remind us.
Your lordship knows that. If you give such a power to Parliament under 356, your lordships, anything can happen. Anything can happen. And well, as I said that the other day, and I'm digressing a bit, with respect to Maharashtra, I said, if Maharashtra is upheld, it will happen again. And it happened in Maharashtra itself. Because we have to protect the Constitution. We don't have to do anything more than that. Our at both sides, mothers, endeavors to protect the Constitution. And your lordship upholds it. That's our task. And upholds it for posterity, not for a particular case.
357(2) of the Constitution of India.
Yes, I will. Which was, I'm sorry, PDF. I got it, yes. Yes, I will. Has ceased to operate, continue in force until altered or repealed or amended by the competent legislature or other authority. That's right.
What's the difference between the two?
Difference is that is 1 year.
1 year.
That's only, that's.
And protection, whatever is.
Yes, in other words, the legislature can undo it. The legislature, because it's been a delegate, before Parliament is a delegate.
But in both the cases, it's law made and exercise the power of legislature.
Yes, absolutely. That if this is a law made, if your lordships believes it's a law made, then within 356, because 356 is to restore democracy, and it's only a temporary measure. And Malat, not only that, you cannot take irreversible action. That also is decided by this court. That during this time, unless your lordship knows the difference between state of Rajasthan and Bomai. In state of Rajasthan, they said, in Bomai, they said, you must dissolve after the proclamation has been accepted by both houses of parliament. You can't do it before, until there's suspension, which is what I was saying yesterday to your lordships. Now, that's irreversible. Therefore, Bomai said you can't do it. Rajasthan said it's possible before approval. Bomai disagreed. That can only happen after approval. But here what happened? It happened before. And it happened without aid and advice. That's even worse. I could have understood if the governor has sent a report way back on 20th of June. I could have understood then. But not in this fashion. Therefore, the whole motive was political, and I've been saying that from day one. The motive was political, the process was political, but the end result was unconstitutional. And I've already pointed that out. Let's not take more time of the court. What did Ambedkar ji say? He said, I cannot altogether deny that there's a possibility of these articles being employed for political purposes. So what I've said before your lordships is no different from what Ambedkar ji said. His fears have turned out to be right. So, Malats, therefore, now come to the argument. I've done with Malats, the dissolution part. I've done with 356. Your Lordships have read all the judgments, Malats. I'm not going to repeat anything. Now I come to the argument of impossibility. An argument not raised, not part of the counter affidavit, not part of any pleadings, not part of any proclamation, not part of arguments the last time also, not part of the first set of written submissions, and yet we have to deal with it. Now, let me tell you, Lordship, the principle of impossibility, constitutional principle. I'll just enunciate it. If there is a constitutional obligation to be performed, and it has to be performed, then in furtherance of that constitutional obligation, the principle of impossibility of performing another obligation. Give your Lordship an example. The term of the assembly is 5 years. Assembly is dissolved in 4.5 years. There is no assembly. And the judgment my learned friend cited, there is a presidential election or election of the vice president, and members of assembly have to vote. But the term of the assembly expires in 5 years' time. The Constitution says you have to perform that obligation. So if the assembly is in dissolution, it's impossible for them to vote. That's the constitutional principle. Where is the obligation under 370? It has to be stated in the Constitution. You can't silently invoke it. And 370 says free bill may, not shall. There is no obligation. That's the principle of impossibility, which has absolutely no application. How is it impossible, Malat? Why is it impossible? No, you've made it possible by acting that the way you've done. That's the way to do it, Malat. Now, whether that's constitutional or not is a different issue. But it's certainly not impossible. If you uphold it, it's not impossible. If you don't uphold it, it's only unconstitutional. Beyond that, your Lordships are not asked to decide. So where is the question of impossibility? That's my answer, Malas. And the judgment that my learned friend cited, Malas, what's that judgment? In the presidential election is exactly that. Namely, the election had to take place, voting had to be done, the assembly was dissolved. So how could they have voted? The proclamation was there. So that's the constitutional principle.